that it can lead to prolonged investigations into your business, litigation, or even prison. You may have seen some of the attention-grabbing headlines with eye-wincing fines and investigations into high-profile companies such as Microsoft, Google, or Intel. You may think that competition law doesn't apply to your business because you don't have market power. Or you may have attended a training session on competition law compliance, but you come away from it thinking, this is just another piece of red tape. Competition law is increasing in its reach. Competition laws are being adopted by countries as diverse as India, Malaysia, and the United Arab Emirates. You are right if you believe that competition law is a serious matter, and it's rising on the boardroom agenda and has reached a level of interest comparable to similar threats to corporate health, such as bribery and corruption. But competition law is not just about what you cannot do, and a greater understanding of competition law can be used to commercial advantage. So whether you stand on the spectrum from skeptic or seasoned expert, it is worth looking at those areas where competition law can actually be used as a tool in commercial decision making. A few examples might illustrate this. You may be thinking about expanding your business's operations to new customers and new markets. Should you use a distribution agreement, a franchise agreement, or another form of business collaboration? Competition law can help with these questions. You may have valuable IP, such as a patent right, and be thinking about licensing that. But how can you do that and protect your business's interests from free riding, consistent with competition law, which typically looks at open markets? What about the question of whether you can lawfully collaborate with your competitors? There are areas where it is legitimate and permissible to engage in cooperation with a competitor, and competition law can help you understand where the boundaries lie. You may be thinking about merging with a competitor. How will that deal be looked at by the authorities? Do you need to tell them in advance? Will any remedies be required? Will they give it their approval? So by sharing these examples, I hope you'll understand that it isn't simply about what you cannot do. But if your company has suffered loss as a result of the anti-competitive activities of another party, then you might have grounds to complain to an authority who can investigate the matter. You might even have a basis for a claim for damages representing the loss that you've suffered. And an understanding of competition law can help you work out where is the right place to bring your concerns and complaints. Let's consider some situations where you might have grounds for concern. You might want to challenge bid rigging by your suppliers, where you're trying to secure the best deal, but because the suppliers have agreed to offer a price which is above the competitive level, you can't really play them off against one another. What about entry into new markets? That might be difficult if the existing players have already stitched up the market by agreeing the customers to whom they will sell and the prices at which they will sell. You may want to challenge the rules of a trade association if you're not permitted to join that and it's restricting your business freedom. The EU rules on state aid may also give you grounds for complaint, where a member state has given an economic advantage on a selective basis to your competitors. It's no longer a level playing field, and you might have grounds to complain to the European Commission because you've been unfairly disadvantaged. Another area is the EU procurement rules, which establish competitive tendering rules for government contracts. If the rules are not followed properly, you may have grounds for concern that you were not given an equal opportunity to compete for that work with your competitors. Now, cartel activity, which is an unlawful agreement between competitors, usually regarding the prices that they'll sell at and the markets they'll sell into, is unlawful irrespective of the market shares or position of the companies involved. You don't have to be dominant to fall foul of cartel rules. That can be contrasted with the rules on abuse of dominance, which address the situation where one party on its own restricts competition through its unilateral actions. There's nothing wrong with holding a dominant position. It's perfectly legitimate to acquire a superior market presence as a result of business acumen, better products, and a superior service. But once a business does have a dominant position, it has a special responsibility not to abuse that dominant position and to restrict competition unfairly. You might have grounds for concern against a dominant company where it is restricting your business freedom through abusive conduct. You may even have concerns that your business could occupy a dominant position, which means that operating within the structure of the law is more difficult because different rules apply to you as a dominant company. Let's consider some examples where conduct by a dominant party would be in breach of competition law. Refusal to supply. Now, there's no obligation to do deals with any party, but for a dominant company that controls essential inputs, such as a supply and distribution network, for it to unfairly refuse to supply or continue supplies to an existing customer can be abusive. It all depends on whether that access is essential to compete in a downstream market. Another example is unlawful tying, requiring a customer to purchase products or services from the dominant company that it does not necessarily want. That can be abusive in certain circumstances. Another example is discounting. It can be abusive for a dominant company to apply certain forms of discounts to its customers, with the result that other parties are excluded from the market. Now, the issue of whether a company occupies a dominant position or is abusing it can be complex, and it can be useful to get expert advice on this issue. So I hope by sharing these examples, I've given you an insight into how a better understanding of competition law can be used as a tool in commercial decision making and in order to further a business's freedom of manoeuvre. I tend to be a glass half full person. I look at opportunities. If that's something that chimes with your thinking, please get in touch with me and let's think about how competition law can be used to business advantage.